Hello and welcome to BYJU'S IAS. Let's get started with the analysis of today's The Hindu newspaper, beginning with a news item on page number 1 of the Delhi edition of The Hindu relevant for GS paper 2. Supreme Court upholds changes to SC/ST atrocities law. Now let's understand this newspaper article in great detail. Article 17 of the Constitution of India talks about untouchability. It says untouchability is abolished and its practice in all its forms is forbidden. But what is this untouchability? Number one, this term untouchability is not defined in the Constitution. But what we know for sure is that this untouchability word in Article 17 is in quotes, which means that we are not talking about literal meaning of this word untouchability. We are talking about something else. Because if we are talking about the literal meaning of this word untouchability, then what Kerala government did, that could also have been untouchability. Now what Kerala government did, all those who came from China or all those who were suspected to have contacted coronavirus, they identified them and kept them in isolation. They were not allowed to mingle with the rest of the population. So could those individuals who were kept in isolation claim that Article 17 has been violated because we are being treated as untouchables? No. That is not untouchability because we are not talking about the literal meaning of this term untouchability. If untouchability is in quotes, then we are referring to something else. We are referring to the historical meaning and interpretation of this word untouchability. And what is that historical meaning of this word untouchability? For example, B.R. Ambedkar, a Dalit, the architect of Indian Constitution, for days together when he was in school, he could not drink water. Why? Because the well from which Dalit community were authorized to fetch water, this well was dry. There were other wells which were full of water, but these wells were meant for the upper castes. That's untouchability. If I was a Dalit, I would move along the road. I had to carry a pot around my neck. And if I had to spit, I had to spit in this pot, not on the floor. This untouchability was based on the concept of purity and pollution. Upper castes were men or women of purity, and lower castes, so-called lower caste, were individuals of pollution. That is why if I was a Dalit, I would move along a road. If I saw an upper caste coming from the other side, I would jump in the mud because my stench will cause pollution to the member of the upper caste who are the individuals of purity. It was in this backdrop that Constitution did not define what untouchability is. Under Article 17, when Constitution said untouchability is abolished and its practice in all its forms is forbidden, this word was kept in quotes. That means we are referring to the historical meaning and interpretation of this term untouchability. But what if individuals practice untouchability? For that we have a law called SC/ST Prevention of Atrocities Act of 1989. What it does, anyone who practices untouchability, he will be booked, and this is a crime in the eyes of the law. Not only those who practice, if individuals preach untouchability, that's also a crime. Not only that, if individuals justify untouchability, even that is a crime. And one big implication of this law is, if there are two individuals, A and B, this individual belongs to upper caste, for example, this individual belongs to either SC or ST. Now what this individual does, he does not allow this individual B to enter into a temple or to enter into a public bus. Now this individual may say that I'm not allowing him to enter into a temple or to get into a bus because this person B is suffering from a communicable disease. That is why I am telling this individual not to enter a temple, not to hop onto a bus. But what the courts in this case will say, what the police in this case will have to assume, that this is a case of untouchability. That means whenever there is a quarrel, whenever there is a dispute between a non-Dalit or non-SC/ST and an SC/ST community member, we will assume that it is a case of untouchability. It is for this individual to convince the judiciary, to convince the authorities that yes, I quarreled with the other individual, but not because of his caste, because of something else. It may be because this person owes him the money, but ultimately he is not repaying that money. So I'm fighting against this individual based on the fact that he is not paying me the promised money back. But here the courts will assume that this is the case of untouchability. It is for the other party to prove that it is otherwise. And in this case, there is no pre-arrest bail, or what we call the anticipatory bail is not allowed for anyone who has been booked under this SC/ST atrocities law, popularly called as the atrocity law. But there were allegations that this law is misused by the SC/ST community. Wrong charges have been filed, wrong complaints have been lodged, and ultimately this law is being misused. And you want to victimize the other side, since there is no anticipatory bail as well, you want to keep these individuals behind bars for a long time, and that is also a punishment. So for this very reason, it was argued that this atrocities law has been misused by the SC/ST community. And then in 2018, in Dr. Subhash Mahajan versus State of Maharashtra, what the Supreme Court ruled, that there will be anticipatory bail granted to those who have been accused under this atrocities law. Against this judgment, there were series of protests in different parts of the country. It was argued that this Supreme Court ruling, what it has done, it has diluted the significance of this SC/ST atrocities law. Then what Parliament did? Parliament amended this law, added section 18 capital A to the SC/ST Atrocities Act of 1989. And because of this amendment, what the Parliament said, that there will be no anticipatory bail. That means the position of this law was restored. Now this amendment was challenged in the court of law. Supreme Court was asked that the order that you gave in 2018, that order has been nullified by Parliament by amending this atrocities law. So please declare this amendment as unconstitutional. But what Supreme Court has done, it has upheld these changes to SC/ST atrocity law. But in this case, what the court has said, in extraordinary circumstances, in rarest of the rare cases, high courts may grant anticipatory bail to those who have been booked under this law if, and if only, there is a prima facie case of malified intent. Prior to this judgment in March 2018, there was no anticipatory bail for those who were booked under this atrocities law. After March 2018, the Supreme Court said, no, you can grant anticipatory bail to those who have been booked under this law because this law has been used, overused, misused by the SC/ST community. But now changes were made. Parliament amended this law and restored the pre-March 2018 status, saying no anticipatory bail can be granted. Now these changes were challenged in the Supreme Court. Supreme Court upheld these changes. Supreme Court upheld section 18 capital A of the atrocities law and said that no anticipatory bail can be given to those who have been booked under this atrocity law. However, high courts have the inherent power. If the High Court feels that a particular complaint, prima facie, at the face of it, is mala fide, is prejudiced, ultimately anticipatory bail may be granted. But this use of anticipatory bail has to be used only in exceptional circumstances. That is what you need to understand from this newspaper article. Now let's look at another news on page number 1. Review court can refer questions to a larger bench. On February 4, 2020, we have discussed the context of this newspaper article in great detail. Very briefly, there was a Sabarimala verdict given by a 5-judge bench of the Supreme Court. Justice Deepak Misra was the Chief Justice of India. By a majority of 4:1, Supreme Court said all women may pray at Sabarimala. Why? Because there were temple rules which says that all women in the age group of 10 to 50, all women of menstruating age, they were denied entry inside the inner sanctum sanctorum of the Sabarimala temple in Kerala. Why? Because the presiding deity, Lord Ayappa, was a celibate or Naishtika Brahmachari. Supreme Court said no, it violates Article 14, it violates Article 15, it violates Article 17 as well. Because for the first time, the Supreme Court said untouchability is not only on the grounds of caste, untouchability can be gender based as well. Gender based untouchability is also protected under Article 17 since you are denying entry to the women of the menstruating age inside the inner sanctum sanctorum of the Sabarimala temple. It is untouchability, and that is why these temple rules are unconstitutional. These rules also violate Article 21 of the Constitution of India. But then, when this verdict was given by the Supreme Court, a review petition was filed. When this review petition was filed, the then Chief Justice of India, Justice Ranjan Gogoi, in an extraordinary move, what he did, he kept this review petition pending. He said, we are not going to hear this review petition unless and until other related petitions are also heard. Which are these other related petitions? Number one, female genital mutilation practiced by the Dawoodi Bohra community. Number two, Muslim women are denied entry inside the mosques or the dargahs. 3. If a Parsi woman marries a non-Parsi, she is denied entry inside the sacred fire temples. What the court said, that all these arguments raised in these three cases are similar to the ones raised in the Sabarimala case. So unless and until we have the clarity on these three issues, we will keep the review petition pending. In fact, what Justice Ranjan Gogoi said, he said maybe a larger bench of the Supreme Court should be set up. 7 questions were raised by Justice Ranjan Gogoi in his verdict. So he wanted a larger bench of the Supreme Court to decide on these 7 questions, which we have discussed on February 4, 2020. And then when Justice Bobde assumed the charge of the Chief Justice of India, he set up a 9-judge constitution bench of the Supreme Court to look at all these questions. This is where a noted jurist, Fali S. Nariman, approached the court and said, judiciary does not have the power. When the judiciary is hearing a review petition, it can't keep the review petition pending. Review petition is to be accepted or rejected. Review petition should be rejected if no error is pointed out in the original judgment. Review petition should be rejected if no new facts have been discovered. Since no new facts were discovered in the review petition, since no error was pointed out in the original verdict, this review petition should have been rejected. While hearing a review petition, you can't ask few more questions and refer larger issues to another bench of the Supreme Court. Justice Bobde said, dear Fali S. Nariman, you have raised an important point. We will get back to you. And now the Supreme Court has got back. Supreme Court has said, what Justice Gogoi did in the review petition, it was novel. It was something unheard of. But nevertheless, it was not wrong. So it is not wrong for Supreme Court, when it is hearing a review petition, it can refer other questions, other matters to another bench of the Supreme Court. And now a 9-judge bench of the Supreme Court will look into all these 7 questions that have been raised, which will define the religious freedoms that we will have in this country under Article 25-26 of the Constitution of India. So if you want to know more about this, you can do 2 things. Number 1, you can watch the 4th February 2020 newspaper analysis, or you can watch the Sabarimala verdict case that is there on our YouTube channel. That is what you need to understand from this newspaper article. Now let's look at another issue on page number 8, relevant again for GS paper 2. Special category status, not a closed chapter, says Andhra Pradesh Chief Minister. What is this special category status? Please understand, don't confuse yourself with Article 371. Article 371 of the Constitution of India talks about special provisions for some states. For example, Maharashtra, Gujarat, Nagaland, Mizoram, Goa, Sikkim, the Hyderabad, Karnataka region. For example, these special provisions are, For Nagaland, any law passed by the parliament may or may not be applicable to the state of Nagaland unless and until the legislature of Nagaland agrees. If those laws passed by the parliament they deal with, if those laws passed by the parliament affect the Naga culture or practices, if they affect the social and religious practices of Nagaland, that means Nagaland has been provided with a special status under Article 371 of the Constitution of India. Any law passed by the parliament, if this law interferes with the Naga culture, interferes with the social and religious practices of Nagaland, this law will not be applicable to the state of Nagaland, or will be applicable only and only if the legislature of Nagaland agrees. Similar protection is available to Mizoram. For Hyderabad Karnataka region, Constitution says under Article 371 capital J that there are 6 backward districts of Hyderabad Karnataka region. For example, Raichur, Gulbarga, Bidar, Bellary. All those who are the residents of these 6 backward districts, they will be provided reservation in jobs. How is it different? Article 16 of the Constitution talks about equality of opportunity in public employment. That means there shall be no discrimination only on the grounds of religion, race, caste, sex, place of birth, descent, as well as residence. That means residence cannot be a qualification for a government job, but an exception to that is provided under Article 371 capital J. If you are a resident of these 6 backward districts of Hyderabad Karnataka region, you can be provided reservation in the government jobs, that too only at the state level. Not at the national level, but only at the state level if you are the resident of these 6 backward districts. What I'm trying to say is that Constitution provides for special provisions for some states. But what is the special category status that Andhra Pradesh Chief Minister is asking for? Andhra Pradesh Chief Minister is not asking for a special status under the Constitution, but he is asking for a special category status which is provided by National Development Council. And what is this special category status? Any state which fulfills this criteria can be provided with a special category status. Hilly and difficult terrain, low population density, or if there is a sizable proportion of tribal population. The strategic location, for example, a state is on the border with a foreign country. If the state is economically and infrastructurally backward, if the state revenue is not much, if the state cannot generate resources and sustain itself, which means it will always be dependent upon the grants given by the center, which means that there is non-viable nature of state finances. If these conditions are satisfied, NDC can grant a special category status on that state. But what is the origin of this special category status? In 1969, the Finance Commission was looking at few states. States such as Nagaland, states such as Jammu and Kashmir. The Finance Commission said that these states, they do not have viable nature of state finances. They are economically and infrastructurally backward. They are also strategically located. So we have to provide concessions to these states. How can we provide concessions? Tax breaks, more funds. That means the idea of special category state status originated in 1969 when the 5th Finance Commission decided that 3 states will be provided tax breaks, additional funding because of these very grounds. And later on, 8 more states got added, so close to 11 states till recently were provided with the status of a special category state. When Andhra Pradesh was bifurcated into Andhra and Telangana, the then Congress government had promised that we will provide Andhra a special category status. This special category status has been asked by Odisha as well, Bihar as well. At some point, Goa also wanted a special category status. But what is the benefit? The benefit is that if there is a centrally sponsored scheme, 90% funds will be given by the center. while the remaining 10% will be given as a loan to the special category status, that too at 0% rate of interest. For other states, which is the general category states, the proportion is 75 is to 25. Preferential treatment is given while the center allocates funds to these states. Concession on excise duty is provided to these states to attract industries to the state. 30% of the gross budget of this center goes to the special category states, which means that the remaining 70% is shared by the general category states. That means more and more benefit is provided to these special category states. And that is precisely the reason why Uttarakhand has developed. There was an index released by the then Chief Economic Advisor of the Government of India, Raghuram Rajan, set up a multi-dimensional index. And this multi-dimensional index ranked the states on various parameters and came out with three lists. Those states which are relatively developed, those states which are less developed, those states which are least developed. And based on that, the most developed Indian state was Goa, followed by Uttarakhand. Since Uttarakhand is a special category state, that is why it was in a position to develop rapidly since it was carved out from Uttar Pradesh. Which means more and more preferential treatment is given to these special category states. And that is why Andhra Pradesh Chief Minister is asking for a special category status. That is what you need to understand from this newspaper article. Now let's look at the Oscars. South Korea's Parasite makes Oscar history. Why? Because it is the first non-English feature film to win two prestigious prizes, both Best Picture as well as the International Feature Film. The director also got the Best Director trophy as well as the Best Original Screenplay award. If you are preparing for state civil services or any other government exam, this newspaper article is very important for you. For UPSC civil services examination, it may not have much relevance. He is the director of the movie Parasite. Bong Joon-ho, Joaquin Phoenix won the Best Actor award for his portrayal in the movie Joker. Can be important for your state level examination. Now let's look at some of the practice questions. After the practice questions, we will look at the editorials and columns from today's newspaper. Practice question number 1. Which among the following statements about electronic voting machine is not correct? An EVM is designed with two units, the control unit and the balloting unit. It's correct. A list of candidates' names and or symbols will be available on the machine with a blue button next to it. It's correct. It makes the process of counting of votes much faster than the conventional system. Correct. EVMs in India was first introduced in 2014 general elections to the parliament. This statement is wrong because it was introduced for the first time in 1982 in a by-election to Paravarur constituency in Kerala. Sendai framework is, it is a 15-year voluntary non-binding agreement which recognizes that the state has the primary role to reduce disaster risk. Let's look at question number 3. Technological development like the Internet of Things and artificial intelligence will permanently change the current working environment. In order to understand the challenges and opportunities provided by these technologies, Future of Work initiative was launched by International Labour Organization. Beirut Declaration, often seen in the news for the peace and development in the Arabian Peninsula and the Middle East, is associated with Arab Free Trade Zone. Question number 5. Which of the following is associated with the Paris Call? Cybersecurity. Let's look at the mains-based questions. Despite stringent laws, why the atrocities against SCs and STs continue unabated? Is there a mismatch between the constitutional guarantees and the empirical reality on the ground? Question number 2. Comment on the powers of the Supreme Court vis-a-vis review petitions. Is there a departure in the standard procedures recently? Now let's look at today's editorials and columns. First up, liberty at the government's whim. The Jammu and Kashmir High Court's recent ruling on preventive detention stands as an antithesis of the Constitution's basic function. What this column tries to highlight is that the fundamental rights that we have, they do not exist in separate silos, but they are all interlinked. which means that if Article 14 provides for right to equality, from right to equality, we can also say that we should have the freedom to move throughout the territory of India. When we have the right of movement, we should also have freedom of speech and expression. When we have freedom of speech and expression, it should not be restricted, because if it is restricted, then my personal life and liberty will also be restricted, which is under Article 21. So what Suhrit Parthasarthi argues, that the fundamental rights that we have, they do not exist in separate silos, but we can derive one fundamental right from the other, or one fundamental right can have an effect on the other. One fundamental right can have a bearing on the other. That is the whole crux of fundamental rights. But what this newspaper column argues, that the recent High Court ruling of Jammu and Kashmir goes against this very idea of fundamental rights. How? Yesterday we discussed Public Safety Act. The intention of this Public Safety Act was to prevent timber smuggling. So all those who may be timber smugglers, they should be detained so that they do not indulge in timber smuggling. Which means that these timber smugglers, they have not committed a crime, but they may commit a crime. To prevent them from committing a crime, to prevent them from timber smuggling, we can detain them under Public Safety Act. That too for 2 years without any trial. That was the objective of this Public Safety Act. But what this newspaper column says, that this PSA is now used to stifle dissent, to stifle disagreement, which is the health bedrock of India's constitution. If we look at Article 21 of the Constitution of India, it talks about right to life and personal liberty. And there have been many judgments in the past which have said that this right to life and personal liberty is inalienable fundamental right, which means that this fundamental right is in a sense available to an individual even without the constitution. Even if there is no constitution, this right to life and personal liberty is still available to the Indians, is still available to the citizens, is still available to the people residing within the territory of India. There was a petition before the Jammu and Kashmir High Court. Public Safety Act was slapped against Jammu and Kashmir High Court Bar Association President Mia Abdul Qayyum. He argued before the High Court that the grounds on which Public Safety Act has been slapped on me, these grounds are arbitrary. Why? Because the grounds mentioned on my PSA dossier are the same on the basis of which an FIR was filed against me in 2008 and 2010. And on the basis of those two FIRs, I have already served my time in the jail. That means 10 years ago, 12 years ago, the charges that were leveled against me, for which I have already served my time in the jail, those charges have been again mentioned in my PSA dossier. So this entire PSA slapping on me is arbitrary. What the court said we will only look at the grounds. We won't look at whether these grounds are credible or not, whether these grounds are justified or not, whether these grounds are correct or not. We will only look at the grounds. And if these grounds have nexus with the law, then we will say that your detention is justified. What is the law? Public Safety Act. What is the objective of Public Safety Act? The objective of Public Safety Act, that it is a preventive detention law. That means individuals may commit a crime. To prevent them from committing the crime, we can book them under Public Safety Act. So there are grounds that are mentioned in your PSA dossier which say that there is a nexus with the objective of the law. That means all these grounds that have been mentioned, they clearly point out in one direction that you may be prejudicial to the security of the state, to the law and order of the state. We won't get into the correctness of these grounds. We won't get into whether on these grounds you were earlier arrested or not. We will only look at the grounds, which basically means that the court is violating due process of law. How? Let me give you an example. Article 21 is not an absolute fundamental right. Your right to life and personal liberty can be snatched from you, but only according to procedure established by law. What is this procedure established by law? Your right to life and personal liberty can be snatched, but for that 3 conditions must be satisfied. First, there must be a law which authorizes that your right to life and personal liberty can be snatched. Number 2, the law must be a valid law. Number 3, the procedures that are mentioned in the law, that are laid down in the law, they have been followed. This procedure established by law protects an individual from the arbitrary actions of the executive. How? Let's say, for example, police is arresting me without any law. Police is arresting me on grounds for which no law exists. The court will set me free. Or the police is arresting me under a law, but that law is not valid. For example, the police is arresting me under section 66 capital A of the IT Act. But this section 66 capital A of IT Act has already been struck down by the judiciary. So if there is a law, but this law is not valid, and I have been arrested under this law, I will be set free by the judiciary. Or third test, procedures in the law which have been laid down in the law must be followed. That means there should be an FIR, there should be a charge sheet, this charge sheet should be filed before the court. Ultimately, it is because of these very reasons, if there is credible evidence against me, my right to life and personal liberty can be snatched. But do you know what's the problem with this procedure established by law? It can protect me only against the arbitrary action of the executive, not against the arbitrary actions of the legislature. Which means, what if there is a law, but this law is unjust? What if the law is valid, but this law is unreasonable? What if there are procedures, but they are not fair? They are not justified? I will have no protection whatsoever. That means procedure established by law can protect you against the executive, but it cannot protect you against the arbitrary actions of the legislature. But in United States, they don't follow procedure established by law, they follow due process of law. Which means, in United States, if an individual's right to life or personal liberty is to be snatched, for that 4 tests must be performed. Test number 1, is there a law which authorizes that this person's right to life and personal liberty should be violated? If yes, second test, is the law valid? If yes, are the procedures mentioned in this law followed or not? Test number 4, is this law fair? Is this law reasonable, just? Are the procedures mentioned in this law reasonable or not? Which means that if the legislature of United States passes an unjust law, passes an unreasonable law, if they mention the procedures which are unjustified, the court will have the power to set this individual free as well. They follow due process of law. In the initial years of our republic, the court said we are following procedure established by law. In the 1950s, in A.K. Gopalan versus State of Madras, Supreme Court said Article 21 talks about procedure established by law. If the law is passed by the parliament, if the law is a valid one, if the procedures that are mentioned in the law have been followed, an individual can afford no protection from the judiciary. Same happened during emergency in 1976 in ADM Jabalpur case. In ADM Jabalpur case, when emergency was imposed, people were arrested under Maintenance of Internal Security Act by the Indira Gandhi government. Student leaders, activists, writers, journalists, politicians, trade union leaders, opposition members, they were booked under MISA. And they filed the petitions of habeas corpus. And it is through habeas corpus that your right to life is given back to you. But in this ADM Jabalpur case, by the majority of 4:1, 4 judges of the Supreme Court said during emergency, habeas corpus is suspended. But luckily, 2 years later, in Maneka Gandhi versus Union of India, what Supreme Court said? Supreme Court said what we follow due process of law. That means even if there is a law, this law must be reasonable. Even if you have passed the procedures, these procedures must be fair, justified as well. That means what we follow in India right now is the due process of law that is followed in the United States of America. In ADM Jabalpur case, when these individuals filed habeas corpus, 4 judges of the Supreme Court said, you have been detained, or the individuals have been detained, but the care that the state is showering on these detainees, it is maternal. Just the way a mother cares for her children, in the same way, the state is taking care of those who the state have arrested. According to Suhrit Parthasarthi, the ghost of ADM Jabalpur is now haunting the judiciary again. Because when PSA was slapped on the Jammu and Kashmir High Court Bar Association, the court said that executive should have the complete immunity to decide when to invoke PSA. We will not get into the correctness of the imposition of PSA. We will not look into the grounds, whether these grounds are justified or not, whether these grounds are credible or not. We will just look at whether there are grounds and is there a link, is there a nexus of the grounds with the objective of the law. If there is the nexus, then ultimately your detention is justified. Amnesty International called PSA as lawless law. Even the Supreme Court in 1982 called the Jammu and Kashmir Public Safety Act as a lawless law. But even then, the Jammu and Kashmir High Court has justified PSA and it has violated the personal life and liberty of a detainee. That is what you need to understand from this newspaper article. Now let's look at the editorial, reservation as right. For that, let's go back to the Constitution. Article 16 says there shall be equality of opportunity in public employment. That means no one should be discriminated against in government jobs. Article 16 clause 2 says that there shall be no discrimination only on the grounds of religion, race, caste, sex, descent, place of birth, residence, or any of them. But important thing here is an exception was created by Article 16 clause 4. 16 clause 4 said there shall be reservation for government posts or government jobs in favor of those who are socially and educationally backward and those who are not adequately represented in the services under the state. In the initial years of our republic, members from SC/ST community were provided reservation in government jobs. Then came the Mandal report. Mandal Commission report said that there should be reservation for OBCs as well, up to 27% of the government jobs. When this reservation policy was implemented by the government, matter went to the court. Supreme Court in Indira Sahni versus Union of India, which is also known as the first Mandal case. In this case, the Supreme Court said reservation for OBCs is justified. But reservation is because of Article 16(4). And Article 16 clause 4 is only an enabling clause. What does that mean? If you look at our YouTube channel, there is a detailed video available on reservations. That's my video. Please have a look at that video. Everything related to reservations will be clear to you. But what Supreme Court said in Indira Sahni versus Union of India 1993, Supreme Court said many things. Number one, reservation is because of Article 16 clause 4. That means Article 16 clause 4 enables reservation. Enabling provisions. That means Article 16(4) enables reservation, enables benefits. One such benefit can be reservation. But reservation is not a fundamental right. Reservation is provided at the discretion of the state. If the state does not want to give reservation, it may also decide in that manner as well. But enabler of reservation is Article 16 clause 4. So if the state has decided to provide reservation to OBCs, it is well within their right. But conditions must be satisfied. Prove to us that these OBCs, they are not adequately represented in these services under the state. Prove it to us. Second important thing that Indira Sahni judgment said is that reservation cannot be on the grounds of economic criteria or economic backwardness. Constitution only defines or talks about two types of backwardness. Either it is social backwardness or educational backwardness. Economic backwardness is not the ground recognized by the Constitution. And third important thing that Indira Sahni judgment said, reservation can be only at the time of the entry. It cannot be at the time of the promotions. Then what Parliament did? It amended the Constitution again. 77th Constitutional Amendment Act in 1995, Article 16(4)(a) was added. And it is this Article 16(4)(a) that provided for reservation in promotion for members belonging to SC and ST community. Even this constitutional amendment was challenged before the court, But in 2006, in Nagaraj case, the Supreme Court said this amendment is valid, but you have to justify, you have to prove to us that members of SC and ST community, they are not adequately represented in the administration. If you can provide this data, if you can provide this quantifiable data, reservation and promotion will also be allowed. But what Uttarakhand government did, Uttarakhand government announced government jobs and decided not to keep these jobs under reservation, and even reservation in promotion was not provided for. Then what happened? A petition was filed in Uttarakhand High Court. Uttarakhand High Court said, how can the state deny reservation and promotion? For that, if you can deny reservation and promotion, please tell us the data. Give us the data that these SCs and STs in fact are adequately represented in administration. Because if they are adequately represented in administration, then you don't have to provide reservation and promotion for them. But if you are not providing us this data, and through this data we cannot understand whether they are adequately represented or not, your actions may not be justified. Now what Supreme Court has done? Supreme Court has said Article 16 clause 4 is an enabling clause. It enables reservation, but reservation is not a fundamental right. What Supreme Court has said? Supreme Court said if Uttarakhand High Court has asked for the data from the state, it is wrong. Because the state is empowered, that it is the discretion of the state to either provide reservation or not provide reservation. Since reservation is not a fundamental right, why are you asking for data from the state? This was wrong. That's what the Supreme Court said in its ruling. What this editorial questions is this: if there is a community or group of communities which are not adequately represented in the administration, is it not the obligation of the state to provide them, to ensure them adequate representation? Now let's look at another column. A mixed Indian healthcare can do without. I'll tell you the biggest takeaway from this newspaper column so that you don't have to read this entire column. It is also too technical and is not relevant for your examination. What is that takeaway? According to the writer, we have been following the US health system for a while now. What is the US health system? More and more private hospitals. That means since public hospitals in India are not in a position to afford quality health to the people, if there are patients, what they can do, they should more and more opt for private hospitals. But private hospitals are costly. For that, insurance cover will be provided by the state. The state will pay these private hospitals for all those patients that these private hospitals may treat. And that is the whole crux of the Ayushman Bharat, a national health protection scheme. But now the problem is, these private hospitals have been accused of fraud. These private hospitals are making fake claims to the government that we have treated these number of patients. They manipulate the claims as well. They manipulate the procedures as well. And ultimately their whole point is to get more and more money from the government under this Ayushman Bharat scheme. Just keep this detail in mind if you were asked to write an answer on Ayushman Bharat. Can be an important additional point in your answer. Beyond that, don't go through this newspaper article. Now let's look at these two columns. Number one, the author says that we are following POW Trinity. What is POW Trinity? P stands for politics, O stands for oil, W stands for the world economy. If the political leadership is strong, if the oil prices are low, if the world economy is growing, India will also grow. Since 2014, we have had stable leadership. There is no coalition government. The price of oil has also fallen down. It was $100 a barrel, then it came down to $40 a barrel. And the global economy also recovered from 2014 because we saw the devastating 2008 economic crisis. But despite this POW Trinity, there is economic crisis in India. The writer is the office bearer of the Congress party, so you may expect a political tinge in this write-up. What this writer says is that there is economic crisis, but government is not accepting that there is an economic crisis. Similar to what happened in China. What happened in China? The mayor of Wuhan where the coronavirus outbreak started, doctors raised an alarm that there are meat sellers who have suddenly started falling ill. When doctors raised this alarm, the mayor of Wuhan said, "Don't do that, don't raise this alarm. Tell everybody that the crisis is not too serious, that entirely everything is preventable and curable." And at the same time, the mayor of Wuhan, what he did, he held an health expo to showcase Wuhan, a top healthcare destination. But ultimately, the mayor of Wuhan could not hide the health pandemic. Similarly, one cannot hide the economic crisis. So, this is how the writer links the two. Health pandemics and economic crises cannot be masked for too long. That's what you need to understand from this column. And here in this column, the writers praise the way India has responded to coronavirus. Number one, swift diplomacy. We got in touch with the Chinese authorities, obtained permission and the support from the Chinese authorities, and we flew Air India planes and evacuated Indians from Wuhan city. Then medical camps were organized, for example, at Manesar, for example, in Delhi. And ultimately, what happened? We were in a position to isolate all those who are suspected to have contacted coronavirus. What we also did on the diplomatic front, we said the visas that were issued to the Chinese, these visas are no longer valid. We screened all the passengers coming from China and put them under thermal screening. And Kerala did spectacularly well. Traced hundreds of those confirmed cases, notified them to integrated disease surveillance program and started monitoring them. And India has also offered help to other countries in the South Asia region, which is part of our neighborhood first policy. In fact, we have also evacuated some of the Maldivian nationals from Wuhan, and we should create more awareness. That's something that is mentioned in the last paragraph. The public too has helped deal with the crisis, particularly by preventing the dissemination of wrong information. We should all observe good hygiene, sanitation practices to prevent infection, because prevention is better than cure. We must, in these circumstances, avoid crowding in public places, and perhaps we must divorce handshake and embrace the traditional namaste. That is one way of preventing the spread of this outbreak. That is it from our newspaper analysis for today. Thank you for being with us. Have a great day.